I wanted to ask you some questions and for us to have a chat about jurisdiction and habitual residence post the end of the Brexit transition period.
Sure.
It now being September, we're almost a year beyond the end of that transition period. And I wondered if there'd been any major changes to the way our courts exercise jurisdiction in children cases.
Well, the really big change is that before the end of the transition period, which, as you know, ran until I think it was 11 p.m. on the 31st of December last year, the main instrument of jurisdiction in children cases was the European regulation known as Brussels II revised. Now, because it's obviously a European regulation, it had to go along with a whole host of others once Brexit came fully to be implemented. And whilst it continues to apply because of various transitional arrangements to cases that started before the end of last year, for all new cases, in other words, those that have begun after the 1st of January of this year, 2021, the instrument of jurisdiction will now be the 1996 Hague Convention, which actually, ironically, predates the Brussels II revised regulation, so it feels a bit like going back in time. But that's really been the major change.
And of course, and you say 11 p.m. on the last day of December, and that's all about the time difference, isn't it, between the UK and mainland Europe? I was wondering, from your perspective, are there any major differences between those two instruments that you've mentioned, so Brussels II revised and the 1996 Hague Convention?
I mean, there certainly are some differences. I wouldn't say they are particularly major differences. I think Brussels II revised overall is a more sophisticated instrument than the 1996 Hague Convention. For example, it contained a specific accelerated scheme for the enforcement of certain access orders, which was obviously useful because in contact cases, if you take a long time to enforce the contact, then that can, make what you're trying to do become academic. There's no equivalent in the 1996 Hague Convention. There are other differences. So, one example is that in the Brussels regulation, once a court was seized of proceedings, it continued to hang on to the case to hang on to jurisdiction until the proceedings came to a conclusion. Whereas under Hague 96, the position is slightly different in that if a child's habitual residence changes mid-case, then jurisdiction changes and in effect follows the habitual residence of the child. But the major similarity between the two instruments is that that in both of them, the main basis for jurisdiction is the habitual residence of the child. So that key connecting factor continues unchanged.
Well, let's come on then to think about habitual residence in a bit more detail, because as you say, that's the key concept, both under Brussels II revised and the 1996 Hague Convention, it being the primary basis for founding jurisdiction. What do the latest cases on habitual residence tell us?
Gosh, it's a very well litigated topic, as you know. I think since 2013, it's been considered by the Supreme Court certainly 5 times, possibly 6 times, which must be something of a world record for a particular area of law being dealt with by our highest courts. In essence, what the Supreme Court has said over and over again is that we've got to apply the European test, which is obviously ironic given that we've now left Europe. But that European test, in a nutshell, says that the habitual residence of a child corresponds to the place where there is some degree of integration in a social and family environment. And really the key words in that sentence are some degree of. There doesn't have to be complete integration, just some degree. And in every case, what the court is trying to do is really work out, whether the degree of integration that the court has, or rather the child has with a particular country, is sufficient to cross the line into making the child's residence habitual. Now, there were a couple of court appeal cases last summer, in other words, the summer of 2020, one called Re-M and another called Re-B.
Yeah.
And in both cases, the Court of Appeal emphasised that every time a court is looking at a question of habitual residence, what it needs to do is undertake a comparative exercise. In other words, compare and contrast the child's connections with the two jurisdictions that are in play on the facts of the case. And what it's really doing is looking at the position as at the date of the application. In other words, you compare not a child's current connections with country A by contrast with the historic connections with country B. You look at both sets of connections as at the relevant date. And the reason for that is it's perfectly possible for a family to have spent, say, 10 years living in Australia, but then decide completely to up sticks and relocate somewhere else. In the first 2 or 3 weeks, or even in the first 2 or 3 months following their move to the new country, they're never going to be as integrated as they are or as they were in their former country. But that won't prevent the child becoming habitually resident in the new country if all previous connections have been severed.
Well, and as you say, it's about some degree of integration, those words that you stressed earlier. Well, thank you, Richard. That's been very interesting. And it may be that there'll be case number 6 or 7 going up to the Supreme Court at some point soon.
I wouldn't be surprised, Alex. Thank you very much.
Thank you.